Good afternoon, everybody. Meredith Nagel here to talk about our new FinCEN reporting requirements. It's 11:59. We're going to give a few minutes to just let everybody join in. We got a good amount of people attending. It's helpful if I'm talking and you have a question about what I'm saying, go ahead and unmute yourself and jump in and ask your question, because if you have a question, that probably means I've not explained it properly and other people have a question. So it works best if we're just interactive. So don't worry about interrupting me. Just unmute yourself and jump in if you have a question as we go through. My hope is when you get done with this, you will have the knowledge that you need to have as a realtor, and how to prepare the parties in the transaction for what we're going to, what these requirements are going to do. Now, a transaction can't close if this information is not provided. If we don't want to hold up closings, we want to be proactive at the time that we go under contract to start gathering the information that's required. So I'm going to share my screen, and somebody shout out and make sure, just let me know that you can see my PowerPoint. Anyone want to tell me you can? Okay, thank you very much. Okay, so the first thing to understand is that this is effective for any closing, any deed recording that happens March 1st or after. This is a new rule that requires that certain information about the transaction be reported to the federal government. It is issued by FinCEN, which is our Financial Economics Crimes Division of the government. The idea is as follows. People were laundering money by opening up an LLC, taking their drug money and purchasing a piece of property for cash, then turning around and selling that property and showing it as money that was clean. The folks that are in charge decided that one way that we could hopefully keep that from happening is requiring that anytime you have a cash transaction, certain information would be reported. So the idea is we're combating money laundering and illicit financing and real estate transactions. In my opinion, bad guys don't mind giving you their fake information. They don't work under their real information anyway, so it's probably nothing but something that's going to frustrate everyone else. But the idea is it's to help with money laundering. So what is required? It's literally called a real estate report, real estate property report. It's filed with FinCEN through their online portal. And the transactions that are covered are as follows. First of all, it has to be either cash, seller financing, or hard money loans. So if the buyer is an LLC or a trust or a nonprofit, this rule applies. Okay? So the rule applies where the buyer is an LLC or a corporation, any business entity, or a trust or a nonprofit, and the transaction is either cash or any financing through any entity that does not have an anti-money laundering program. So some of our credit unions, some of the smaller ones, are not included in the anti-money laundering federal program. Seller financing is at issue here, and as well as hard money lending. So if it's cash, hard money loan, any loans at all that are not covered by the anti-money laundering statute, so that means like Bank of America or whatever, and the buyer is an LLC, a trust, or nonprofit, this reporting must be made. Any questions thus far as to what it applies? So think anytime you see cash or seller financing or any kind of financing that's not normal financing, and the buyer is a business entity or a trust, you know that this rule is going to apply. Now, it applies when it's residential property or vacant land that could be used for residential property. So it doesn't apply to commercial transactions unless the commercial transaction is going to have some component of residential. So if a commercial buyer is going to put apartments in a Publix, it applies. So it's has to be residential or vacant land to be used for residential. So if somebody buys a lot and they're going to later get financing and build a home on it, if it is a residential zoning, then this rule is going to apply. So who has to report? Good news is realtors don't have any obligation. Yay! The only obligations you guys have is to help us collect the information and to prepare your customers for what's coming. So this first falls on the title agent or the attorney, anyone who is preparing the document. It is not filed by the buyers directly. It is filed through their agent, whoever prepares the deed. Theoretically, if a buyer prepares their own deed, they should do it, but they're not going to know how to do it. But in any event, it's not anything y'all have to do. You just have to know about it, and you have to prepare your folks to provide the information. So let's recap. I want to keep saying this over and over till it's in our head. Residential property or vacant land that could be used, zone residential, cash transaction, seller financing, or any financing that is not covered by the anti-money laundering statute. So that means hard money loans. That's where this rule applies. So the reporting itself is so detailed that the that the filing instructions, how to file, the instructions alone are 39 pages long. This happens right now in some parts of South Florida. They've had this rule for a while, and it's taking on average 2 hours to fill out the reported information into the FinCEN portal. So what has to be reported? First of all, the property address, the date of the transfer, the purchase price, and the type of residential property. So that's going to be reported for the transaction as a whole. For the sellers, when this is at issue, we have to provide their full legal name, their street address, residential only, social security number, date of birth, and some type of government issued ID. So a valid driver's license or a passport or one of the other qualifying government IDs. So that is reported for the seller. As you can imagine, this is going to be one database that's going to have a lot of very sensitive information subject to being hacked. So that worries me a little bit, but we got to deal with it. So what do you have to do for the business entity? So you have to disclose or identify the name, the principal address, the tax ID number, and your entity level identification. What type of entity is it? Then in addition to that, if it's a trust, not an LLC or a business, you have to have the trust, you have to have the date it was executed, the tax ID number, the trustees, individual social security numbers, as well as beneficiaries and trust protectors. So that's what has to be disclosed on the seller side. On the buyer side, the same information, meaning the legal name, principal place of business, tax identification number, but then in addition to that, in addition to the information about the business generally or the trust generally, you also then, if anyone has substantial control of the company, which means a CEO, manager, president, anyone owning 25% or more of the entity, and anyone authorized to sign on behalf of the entity, we have to get from them their name, residential address, date of birth, taxpayer ID, and the government issued ID information. So what that means is if you're dealing with a client who has an LLC, generally there's one person that signs, but we've got to then get all this identifying information from every person who owns at least 25% of the company, and those people, if they're different, that have management responsibility, and those people that are going to be signing. So that specific information has to be collected. All of this information has to be certified by someone from the entity is actually signing a certification that the information that they're giving us is true. For a trust, you have to get all of the same information for the trustee, the settlors, the beneficiaries, anybody with authority to revoke. All of that same personal information is required. So just think in your mind, you're going to have to get the personal ID information from everybody that has any say in the company, any say in the trust. Also, concerningly, we have to provide the method and place of payment. So we have to give over the name of the bank and the account number and account name that was used to fund the transaction. That has to be provided as well. So what this is going to mean for you guys is as follows. People need to know ahead of time that they're going to have to give over this information, and some of them are not going to want to do it. And I can understand that. You need to prepare them ahead of time because we don't want to hold up your closing. Where I see a problem is sometimes people, are moving along and then they tell you a week before closing, oh, we talked to our lawyer and we decided that we're going to close in an LLC. Let them know ahead of time. If they're even considering that, they need to go ahead and make the decision early because it could hold up closing to get all this information. There's the penalties if this isn't done correctly are tremendous, huge fines. So for that reason, everyone is trying to be very, very, very careful. Now, the amended contract that you guys are going to get that's going to be available to you effective March 1st will have a provision that this information in cooperation with this real estate reporting requirement is going to be there. And it's going to say that the cost of this is to be borne by the buyer. Now, I'm having people ask, how much do we think it's going to cost? We're not precisely sure because in the title industry right now, what we're doing is trying to figure out how this reporting is going to be made. It seems like the settlement software is going to interact with a third-party software that is going to make these reportings. So we don't know. It could be anywhere between $200 and $500. It's too soon to tell. Because it's all being shaken out right now. I mean, there's even right now still some software being created to try to, address how this is going to work. How is it going to, integrate with the information that we're already collecting as part of the transaction. So, all right, you should be able to see my face now. All right, so do we have any questions? Let me go over it one more time. This rule applies if it is cash or seller financing or hard money loans or any institution that is not large enough that it has to comply with the anti-money laundering statutes. And the property is residential or vacant that is zoned residential. And the buyer is either a business entity of some kind or a trust or a nonprofit. When you have those in place, then this additional level of reporting is required. The information to be collected, again, reminder, it's what'll be people will find burdensome is they have to give their home addresses. We can't use any PO boxes. They have to give over their driver's license or passport ID or other government issued ID. And we have to get the bank account information, including the bank name and the bank number and social security numbers. So this is a lot of private information that has to be collected up and transmitted. So prepare your people for what is coming. And let them know that, again, if it is not unusual for someone a week before closing to come to us and say, hey, we need to change everything to the name of our LLC because our, attorney said that would be a good idea. Well, that could slow up the closing. Gus, question.
Yeah, so I actually have just three questions. One is with regard to trusts.
Yes.
Obviously there's a lot of information that's going to be shared with a title company. Do we know if any of uh, the trustee information will become publicly available, or will that still remain confidential?
No, trustee information has to be given over. Not only the trustee, but also the beneficiary and also the trust protector. Some trusts have trust protectors that have powers within the trust. So basically, anybody that has any kind of rights in the trust, we have to give all of that specific information over.
Do we know if that will be so right now, for example, I can find out the owners of an LLC. I can't
Right.
find out the owners of a trust. Am
Nope.
I will that be changing? Will now it be will the trustee information be available to the public to see, or is that
No,
just
that's
for the reporting
important
purposes?
question. That's important. This is not going to be publicly available information. This is not going into a database anywhere that the public can get into unless it's hacked. This reporting is the information is collected by the title team and then transmitted to the FinCEN portal, but it's not then going into Sunbiz or any other place where you could find out information.
Okay. The other question I had is really quickly when you had mentioned certified by the trustee, right?
Or whoever's reporting. There has to be,
Okay.
so for the company or for the trust, someone has to be the official reporter of the information, and they have to certify that the information that they have given over is truthful.
Is that anything that the agent would need to be doing, or is that something that you guys do as a title company?
No, we do that as a title company.
Okay,
All you guys need to do as the agent is prepare your buyers that there's going to be an additional cost because of this FinCEN reporting, and let them know that all of this sensitive information is going to have to be given over and reported into this portal. Now, what's interesting is that sensitive information has to be put into the portal for the sellers as well when it's one of these transactions that covered. So, you need to let your people know because they're not going to be thrilled about it, but there's no way around it. If you represent the seller and the buyer is an LLC, you need to let your seller know that their information is going to be collected and put into this FinCEN database.
that's interesting. And then the only
Now,
other question I had real quick is time frame. How long do you imagine it's going to take for this reporting process? Is that going to be something that can happen in a few days, in a couple weeks? Do we have an idea of what that window looks like?
so that is an excellent question, and none of us have any idea yet. When I tell you that now, just now, the companies are trying to scramble to put their software together to figure out how this is all going to work, I'm not exaggerating. Like, we don't know yet. We know that the reporting has to be done no later than 30 days after closing, but every closing agent is going to take the position that they will not close without it because it's hard enough to get information from people prior to closing. Good luck trying to get somebody's attention after closing. So nobody's going to close your transaction without having all this information ahead of time and having the reporting put in. And how it's going to slow down closings, we don't know. It's going to depend, honestly, entirely on how responsive the parties are. So that's what falls on you guys as the agents, to let your buyer know. If you're representing a buyer and they're an LLC or a trust, tell them to go ahead and get all the information together now. We'll send you this PowerPoint so that anybody that wants it, just let me know. And it details what you have to get from them. But if you represent the buyer ahead of time, go ahead and have them collect it up so that they're ready. We use a settlement software called Qualia, which a lot of other title companies use as well. There's actually going to be a module now for that information to be put in by your clients. So, and us. So preparing them ahead of time is gonna help not delay your closing. Now, the other thing I want to touch on is this also applies if there's no money changing hands. So you can't get around it if your folks say, okay, I'll buy it in my own name and then I'll put it in the name of my LLC after closing. That doesn't work. This reporting is required even if if you give it to someone for free. And that's because they figured, well, the bad guys would try to get around it by changing money outside the transaction. So even if it's free, even if you just give your property, like our clients on the law side that want to put their property into an LLC, we are now going to have to do this reporting. So it's a big deal. Excellent questions. Any other questions?
I have a question.
Yes.
Do you see this as being a good thing or the government just trying to like control things more?
My opinion is it's a bad thing. In my opinion, people who launder money will be very glad to give false IDs to get around this problem. And it's just one more additional layer of nonsense. There are some people that say that there is a back channel reason. There people in the government have been for some time trying to get their hands around individual wealth. You've heard folks talk about there's been some move recently to try to amend the tax filing so that you have to report everything you own. So we could go as deep into conspiracy theories as you want to, but even for the stated purpose, which is to try to prevent money laundering, I don't know people who launder money that do things in their own name anyway. So, but the powers that be, that are the federal government, decided otherwise. So now the buyers have to pay the price. And again, I have to let you know, the sellers have to provide all that specific information as well. You can make sure to let your folks know that it is not going to be publicly available. So it's not like it's going in the, Sunbiz or any other place that it could be available publicly, but it will be available to the government and to whoever ends up hacking the data.
I have one more question to that.
Uh-huh.
Is there any liability this would be me asking you as an attorney, is there any potential liability that can happen if they're aware that this could happen and a seller specifically decides not to accept an offer from an LLC or a trust because they don't want to have to do that kind of reporting? Is there any
No, you're
liability
allowed to
that
sell.
could-
You're allowed to sell your property to whomever you want to sell your property to.
Okay.
That's how that works. Now, if somebody, there may be issues under your contracts and your listing agreement. If somebody presents a full price offer and they don't follow through on it or something like that, that's another matter. But any seller who doesn't want to participate doesn't have to. And that's why the contract says and includes the clause, the ones that are going to be available to you after March 1st, that this requires the cooperation of all parties and that the cost for this is to be borne by the buyer.
So what if the buyer is getting a standard loan, but the seller has the LLC or the trust? I'm sorry, but yeah, the seller has the LLC or the trust. Would that apply?
No, ma'am. The only time this applies is if the buyer is the LLC, trust, or nonprofit. They don't care who the seller is, only the buyer. That's the only time it's relevant. Now, if the seller is a company and the buyer is a company, we have to report for the seller entity the tax ID number and all of that of the entity itself, but we don't have to get all that specific information for every owner like we do for the buy side. So it's really a buy side problem. And providing the bank account information is troublesome. A lot of people are not going to like the fact that that's going to have to be reported, and whatever bank account that they're going to pay out of when they do the reporting is the bank account they have to use when they then go to close and fund the transaction. So you're going to need to let them know that too, in terms of people, how they move around money sometimes. If you have cash buyers, they move money from their personal account into an LLC account to purchase. We're going to have to source the funds and report the funds as of how it closes. So keep that in mind as well.
Would you suggest if they're sourcing the funds and have all this account information for them to change accounts after the transaction's completed?
Yeah, I know you're kind of joking, but it does concern me that all of this personal identification, especially residential addresses, that is concerning to me. And that is a level of information for business entities that we have no other place that has to be reported, including on tax returns. So I don't love it. I don't love all of this information being held in one place that, presumably anybody in the government that is interested can look at. But, here again, people smarter than me decided that this was something we needed to do.
I'd like to ask one question though, just to reiterate, this is only for cash deals on residential going into a trust. If a mortgage is involved and it is a trust, that does not apply. It's only a cash deal going into the trust, the all of the other, I can't even think of them.
Yeah,
all.
cash deal. So cash deal, seller financing, hard money lenders, and some credit unions.
Right, the
But
smaller
not
one.
every bank is required to participate in the federal anti-money laundering program. But, if it's Bank of America, Rocket Mortgage, any of those people, that you're not worried about. But, seller financing and hard money lending, as well as some of the smaller credit unions. So one of the things that we do on title side is when we see the loan come in, if it's not an obvious one, we will be for our file documenting that they do in fact have that they are in fact governed by the anti-money laundering statutes. So our team will be doing that to just make sure if it's from a entity that is unusual, some of the smaller credit unions or whatever, we will be making sure to document that they are covered by the anti-money laundering. And if they're not, we will let the buyer know. And of course, then kick into gear all of this information that has to be collected.
Okay, thank you. That's what I needed.
Yep. And again, it's not just cash, also for free.
Correct.
That doesn't matter to you guys so much, but it matters on the law side because, as you guys can imagine, people pass property around all the time, and this reporting is going to apply to them as well. So
very good.
Yeah.
So if a LLC is buying like a fix and flip, and sometimes in their offer they use their own title company, or they do the closing and pay for it, how do we know that it's reported when it's all basically the same entity?
Well, the good news for you, Diane, is you guys have no liability under any of this. As a realtor, or an agent, it's not a realtor, there is no liability on you guys unless you are actively participating in fraud. So it is not your job, or you cannot be liable if my company messes something up. That is not your responsibility. You don't have to worry about that at all. There is no liability that flows through to the realtor unless for some reason you have to do something dumb like prepare deeds for people, because it does follow through to whoever prepared deeds, which none of y'all should be doing anyway. But for y'all, it's not a liability issue. It's a management of the client issue so that you can make sure that your closing stays on track and people are prepared.
Now, presumably the reason why traditional loans it wouldn't be necessary for you to report that is because these banks are already doing that when they're actually going through the loan process and underwriting process. Is that why?
That is why, because they are governed by once your bank is of a certain size, you have to participate in the federal government's anti-money laundering program, which includes things like you guys might generally know that if you make a deposit of more than $10,000 at a time, a bank has to report that. That is part of the anti-money laundering rules. But the big banks already have to demonstrate that they're verifying identifications, and that is they already have a program whereby that information is transmitted. So it does not apply. But again, it falls on our team. Our team will be making sure, again, unless it's some obvious, Rocket Mortgage, Bank of America, if we see anything that's a little funky as the lender, we'll be reaching out to confirm whether or not they are participating in the anti-money laundering program. But again, no liability on you guys. This is only a get people going, warning that it's coming, helping your buyer LLCs go ahead and collect this information right away, just so that closing won't be delayed. It's not any liability on you guys, except for the liability y'all always have if you're participating in fraud, which none of you are. So that's not anything to worry about.
I have a question.
Hey, Valerie.
Hi. So I guess my question is how it relates to the as-is contract in section 9 of the contract when it's talking about designating title companies. If a buyer's agent looks at their buyer and says, I've got a buyer that fits all this criteria, would it be prudent for them to go ahead and kind of suggest that their buyer picks the title company so they can go with somebody that they've used and they trust, since they'll be dealing with all of this more sensitive information? Or is there any sort of way to tell what title companies would be better to work with than others? Because all of them are not created equally, obviously. But is there any sort of designation for that?
Yeah, that's a good question. I hadn't thought it through. Well, first of all, if the buyer is going to choose concierge title, then you should absolutely choose buyer choose.
Yeah.
And just easy. Here again, it is sensitive information, and I can understand people being concerned. In terms of, liability, the only concern that you might have is a title company that might not be careful with all of this private information. And I can't say any more than that. Are there going to be bad actors that take this information and sell it to marketing companies? Abso-friggin-lutely. That's absolutely going to happen. It is. Any place that there is time to make money by stealing, people will do. But, title companies that you trust, certainly all of the major chains, they're going to be trustworthy. A title company already has a lot of personal information, so I can understand. But yeah, I know there's a lot of fly-by-night people, and I guess that's all I can say about that. But yes, it is collecting a lot of personal information that's going to be in the hands of an employee, and there's no way around it. Any other questions? All right, so I want to recap it once more just so we've got it in our head. Buyer is an LLC or a trust or a nonprofit or a PA or a corporation, any kind of business entity, and it's residential or vacant land that could be used for residential. And for you, Gus, that does include a commercial purchase where the developer is going to have mixed use that includes residential. Okay, for those of you who do commercial. So if there's going to be any residential use or possible residential use, and it's either cash, seller finance, hard money loan, anything not covered by the anti-money laundering statute. And we will, if you are representing the buyer and they've got a funky lender, we will make sure whether or not it's covered. Your new contracts available to you will have this provision. There's a revision effective March 1st. They might be out already. I haven't checked, but it says that this if compliance with this is required, and it makes it clear that it is a buyer cost. Have I explained it well enough? Do we feel anybody, if you're walking out of here and you have any more questions, please shout it out.
I just want to clarify because you said and. So if Joe and, Linda Smith are purchasing it with cash in their individual names, this is not required. It would have to be if it was their trust, right?
Yeah, it's only required when the buyer is an LLC, corporation, PA, any business entity, or a trust.
Okay.
or a nonprofit.
Okay. I just wanted to confirm because I heard you say the and, so I'm like, okay. I
Yes.
just wanted to
Yep.
confirm. Thank you.
So cash, seller financing, hard money loan, and residential or vacant land zoned residential, or Gus, for our commercial people, going to have a mixed use that includes residential, and seller financing. I think I covered it all. Business entity, seller financing, cash, hard money loan, residential or vacant land that could be used for residential. Then all of that information must be reported to the FinCEN.
Does it matter the amount that's being seller financed? So for
Nope.
example, okay, so if they bought with a loan, like an SBA loan, and then the seller is willing to take a second note for a portion of the down payment, they would have to go through this process.
Yes. I know. Burdensome. Any more questions? Have we got it? Do we think we have it? And to reiterate, this is not a liability on you guys. All you have to do is prepare the people in the transaction that this is information is going to be collected up and that they have no choice but to provide it. The transaction cannot close without that information being provided.
I have one question, Meredith. Sorry,
Yes.
I can't find the hand to raise.
That's okay.
Did you say that they're going to update the contracts? Are we going to have a FAR bar that has anything in it, or we just
Yes.
think this is just knowledge for us?
No, the FAR bar is going to have the provision. I have been told that the FAR bar is being updated to add this specifically, and I saw what the language is going to look like, but I haven't gone into my form simplicity and seen if it's in there yet. But it's
I looked yesterday. I couldn't find anything.
It's supposed to be available to you guys effective March 1st. And it's supposed to have this language that I've seen that says the parties have to comply, kind of like, FERPTA, the parties have to comply, and that it will be the cost of the buyer.
Perfect. Thank you.
You're welcome.
I do have a question, Meredith.
Hey, Lori.
Hey, just to piggyback on Brandy's question regarding if the buyers are cash buyers and it's in their name, they do not have to.
Nope.
That's correct. Okay, I just want to verify that.
Yeah, I just want you guys to think in your brain, the two triggers are a business entity of any kind or a trust and residential or vacant land that can be used for residential. That's the only time it applies. And of course, cash or seller financing. If they have regular Bank of America, if an LLC is buying and they're getting their funding through Bank of America, this does not apply. So you have to have all three buckets. It has to be residential, or vacant land to be used for residential, and it has to be a business entity or a trust, and it has to be either cash, seller financing, hard money lending, or any other lender that's not covered by the anti-money laundering statute. We got it?
I have one more commercial question.
Yes.
So I deal with a number of investment groups, and they tend to have pretty deep list of investor pool. So if they are looking to purchase something cash, are all of the investors required to be reported on for that purchase, or is it just going to be general partners, or how does that work?
So anybody that owns 25% or more.
Oh, you mentioned that. Yes. Okay.
And even if they don't have ownership interest, if they're an officer and anyone signing on behalf of the corporation or entity, if it's someone different. So like if they have an authorized signatory instead of themselves, we got to get all that information for the signatory as well.
Okay.
So anybody that has 25% or more, and they are not going to want to give over their residential addresses.
Yeah.
I don't blame them, but we have to.
Does citizenship matter?
Nope.
Okay.
It does not. None of the rules are changed. Whether you're here buying in whatever capacity you're buying, doesn't matter at all. Any other questions, you guys? I want to make sure that we leave here with this really ingrained in our brain.
I appreciate you sharing this information. This is blowing my mind right now. And I'm trying to figure out how, because I also, you know, obviously I do some coaching with residential agents. So just kind of sharing this as well as how I would leverage this in my business. And this is going to be really impactful. Um, I have a few buyers right now that are looking to purchase some commercial projects and they're looking to buy cash. And this is going to be information they're going to need to know about.
Yeah, if all they're going to do is put commercial there, fine. But if they're going to put apartments, townhomes,
Multifamily.
exactly, it's going to be all this is going to have to be reported for every person who owns 25% or more. Or, you know, sometimes people have a manager of an LLC that's not an owner. We have to get it from that person. Or like, again, you guys have seen sometimes where there's an authorized signatory who's not actually an owner of the company. We got to get that from them too. Their personal identification number, their social security number, and their residential street address. And the bank account name and account number. Yucky.
Firstborn, blood type.
Exactly.
Example.
Any other questions, you guys?
Meredith, you said you're going to be sending something for us to be able to print out, or you're going to send it.
Yeah, let me put in the chat. Let me put right now the email address. If you want a copy of the PowerPoint so you can have it to hand, just to remind yourself, send an email to lisa.perez@mnagellaw.com. I put her information in the chat. We'll send it to you just so that you can refresh your recollection. All right, as usual, if you guys have any questions about anything, here's my cell phone number. Give me a call. I'm always here to help, whether it's closing here or not. If you have any questions or if you have any issues, give me a call and I'll be glad to assist in any way I can. All right, thank you guys.